Today we're going to talk about contracts for your business. Regardless of what type of business you're in, every business should use contracts. If you're a landlord, commercial or residential, a contractor, whether you're a general contractor, subcontractor, or even in a service industry, computer techs, consultants, and so on, you're going to want to utilize the best contracts available to you. Let me give you some examples. If you were a landlord, you'd be looking at utilizing good solid rental agreements. In a business, you may be looking at partners and entering into partnership agreements. Employers are going to want to have employment agreements with their employees. In a real estate transaction, you want to utilize a purchase and sale agreement. Some other examples could include service contracts, independent contractor agreements, promissory notes, consultant agreements, and those are but a few of the examples that are available to you. But I want you to think of those in the context of your business and decide what's applicable to you. The purpose of the contract is to clarify the parties' expectations. You can define the terms and conditions of the contract itself. When you think of the price, fees, charges, those sort of things, that will help the parties understand the fiscal aspects of this contractual relationship. If we're talking about quantity and or the quality of things like products, goods, services, those should be well defined. What about timelines? How long is somebody going to be granted in order to be able to provide unto you the services or the goods that you're going to be paying the price for? Define those clearly, and everybody will be able to understand what they're getting into. Now, when we talk about contracts, a lot of people are going to be thinking about the written document itself. But there can be verbal agreements, and a verbal contract is supposed to be just as enforceable as a written contract, but truly it may be harder to enforce. The terms and conditions are easier to dispute just because of the fact that they were verbal and the parties may have differing recollections as to what the terms of the agreement were. And it may not provide for the desired remedies. You might find that the verbal agreement that you entered into, if breached, didn't do for you that which you wanted it to do. And as we're talking about defaults, I want to make sure that your good, solid written contract actually defines what a default is. And the reason you want to define the default is that you want to know what's going to occur in the event of a default. So I want to look at the default remedies. Is the remedy going to be to file a lawsuit, assert some sort of lien, foreclose upon that lien? What happens if you have to incur attorney fees? Are those going to be covered? What about default interest rates or late fees? Do you want to have those added on to whatever the other side might owe you in the event of a default? What happens if you're sitting here in Oregon and the party with whom you've contracted is sitting out in Missouri or Minnesota or Maine? You want to have a choice of jurisdiction clause so that that way you can litigate here. And maybe you want to utilize a dispute resolution forum clause so that that way you can go into arbitration instead of utilizing the court system. When we look at the second part of the purposes, I want you to be aware of the fact that the contract lets you know what you're getting into. That's probably the single most important aspect of it to me. It's going to help you avoid disputes because the parties are going to know what they're supposed to be doing. It will help you, if well written, enforce the contract in your favor, and it will help ensure the success of your business. If you do have any other questions with regard to contracts or any other matter relating to your business, please don't hesitate to contact me.